The Liz Wheeler Show. We are live right here on X. We are live on YouTube. We are live on Facebook. Drop me a wave in the live chat. Tell me you are here. We have a fantastic show for you today because, guys, this is it. We wondered what it would be. We wondered what the left was going to do. We knew they wouldn't take a Trump victory in November lying down. They wouldn't accept our mandate as the voters that we want an America First agenda coming from the White House. We knew that there was going to be resistance. We just didn't know what that resistance would be. Would they take to the streets? Would there be Black Lives Matter style riots, the summer of rage in 2020 all over again? Would they be breaking windows and looting luxury purses and assaulting cops and throwing Molotov cocktails like they did in New York City, all in the interest of social justice? Would it be lawfare against President Trump, false accusations against him, district attorneys funded by Soros indicting him for stupid things that aren't crimes just to get the mugshot of the century? What would it be? I didn't know what it would be before the election. I knew they would do something. I didn't know what it would be. Would it be mainstream media lies and smears painting him as a Russian agent? Would it be another attempt to impeach him because he asked, this is so ironic now, because he asked Zelensky about the Biden family crime cartel and how they were cashing out with the Ukrainian oligarchs? Would it be another assassination attempt? We'd already seen two in the space of just last summer. What would it be? We knew the resistance, while they might have been discombobulated, Kamala Harris might have spent the DNC's entire war chest. We knew these people are ideologues. They're not going to take this victory lying down. They're not going to give up. What are they going to do? Well, we now have the answer. This is it. This is what the resistance to Trump is going to be. It is going to be judicial activists, that is, judges sitting on federal benches who are attempting, actually exceeding the authority of their bench to try to stop President Trump's executive orders. We have judges blocking Trump's spending freeze. We have a judge that's trying to force the Trump administration to restore pages to health agency websites on gender ideology. Put that transgender ideology back in the Trump administration, a judge says, as if the judge has any right to do that. The Daily Caller is keeping a running list of all these injunctions that judges are issuing against Trump executive orders. And this is what they write. A federal judge in Maryland blocked Trump from restricting hospitals that offer child sex change procedures from receiving federal funds. Another judge in Washington, D.C. also blocked Trump from terminating foreign aid contracts and grants issued prior to his inauguration. A federal appeals court rejected the administration's request on Tuesday to lift an order blocking its funding freeze. A federal judge lifted a temporary freeze on Trump's buyout offer for federal workers on Wednesday, but that was only after another judge said that Trump actually couldn't offer a buyout to federal workers. And this is only the beginning. This is it. This is it. We talked about this briefly on the show last week. There's so much clarity that we have been given because now we know the beast that we are dealing with. Now we can name it and we can defeat it. And that is what we are going to do today. Do these judges have the legal authority to issue nationwide injunctions? Does President Trump, the Trump administration, do we have a legal and moral obligation to follow what these judges are ruling? Is this a valid thing that the Trump administration is doing with DOGE? Is DOGE actually a legal entity? Who's behind these judicial activists? Because it's not just that the judges are corrupt. They are corrupt, and we're going to show you some federal money that might be motivating at least one of these judges. But there has to be an organized effort behind these judges. And what we're going to do today on the show is we are going to unpack exactly who is behind this effort from these radical leftists who've been sitting on the bench thanks to Obama for decades. What group is behind them? What individuals are behind them? What is the motivating factor? Because once we can unpack this attack on the Trump administration, this attack on our mandate that we, the voters, gave to Trump, then we will adequately be able to stop it. So we're going to talk about two names. You've probably heard at least one of these names, Mark Elias. Mark Elias is a Democrat super lawyer. Mark Elias was the Democrat operative who was largely responsible for staging all of the electioneering of the 2020 election. He was the one who spearheaded the efforts to change whether it was rules or election-related law that allowed universal mail-in ballots, that allowed signature verification degradation on those universal mail-in ballots, unmanned drop boxes. absentee ballots that were accepted after voting day. Mark Elias was behind those legal efforts. So we're going to talk about Mark Elias again because he's rearing his ugly head. He is involved in this as well, and maybe more than anyone had any idea until he formed an organization in late December whose sole purpose is doing exactly to Trump what these judicial activists are doing to Trump right now. We're going to talk about Mark Elias, and we're going to talk about another Democrat lawyer, Norm Eisen, and what these two together strategically have planned for Trump. We're also going to talk about some of these judges. Matt Bates is the name of one of these judges, and we're going to talk about him because his wife, the wife of Judge Matt Bates, gets money from U.S. aid. That's right. The agency that Elon Musk focused on as his first effort in doging the federal government. It seems like a little conflict of interest that a judge here who says that the Trump administration must restore pages on federal websites about gender ideology that his wife gets U.S. aid money. Just a little coincidence here. Matt Bates also presided over the Matt Perna case. Matt Perna was the J6 defendant who killed himself after Judge Matt Bates rigged the trial, we'll say, or there was significant lawfare, unjust lawfare involved in that trial, and Matt Perna committed suicide as a result. And then, of course, we're going to talk about DOGE itself, this entity. Is what Elon Musk is doing at the direction of President Trump, doging the federal government, identifying corruption, this billions and billions of dollars in wasteful spending and eliminating it. Is this legal? Is it airtight? Does Trump have a right to establish DOGE and a right to ask Elon Musk to lead the DOGE effort? And the answer to that is actually quite funny. The answer is yes, but the answer why is thanks to Barack Obama, actually. So we're going to get into all of this and more with a constitutional attorney today on the Liz Wheeler Show. He's going to be joining me in just a moment. But I want to start by making a note about ivermectin. You've heard the controversy about ivermectin. Ivermectin worked against COVID, but the public health officials, the pharmacists, the doctors, the politicians, the mainstream media talking heads told us it was a horse drug, a cow drug. Don't use it against COVID. They said it doesn't work, even though the studies show that it does. Ivermectin has been safely used for decades. And I do not want to be in a situation, and I'm sure you agree with me, where we do not have the choice to take the medicine that we believe we need when facing a novel coronavirus from China, for example. Basically, emergencies don't wait, whether it's the wildfires in California, hurricanes in the southeast, or another global health crisis. Aren't we being told that we're facing a quademic now? Having the right resources matters. That's why All Family Pharmacy offers over 200 different medications and bundled emergency packages to ensure that you are ready for anything. At the heart of this effort is the Make America Healthy Again movement. It's a call to take control of your health and prepare for the unexpected. And if you find yourself in a pinch, All Family Pharmacy has you covered with overnight delivery. That is care and convenience when you need it most. So go check out allfamilypharmacy.com/Liz. And because you are part of this movement, use code Liz10 at checkout for an exclusive discount. Again, that's allfamilypharmacy.com/Liz, code Liz10. All right, Josh Hammer of The Josh Hammer Show and of America on Trial, which I've told you before is I don't listen to very many podcasts because I'm a very busy mother. America on Trial is one of the few podcasts I do listen to because Josh Hammer knows what's going on when it comes to any type of legal issue in our country. He's one of my favorite podcast hosts and friends. So Josh, thanks for joining the show.
Liz, it's my pleasure. Thanks as always for having me.
All right, Josh. So, I texted you late last week and I said, listen, what is up with these activist judges from a legal standpoint? Do they have a right? Do they have the authority, basically? Not do they have the right? Do they have the authority based on their position on these federal benches to issue these nationwide injunctions that are overruling Trump's executive orders? And you sent me, of course, as you often do, about 3,000 words in response, which I appreciate, actually. I feel very educated after you give me this instruction. But I wanted to bring you on the show today because I want you to explain something that I did not know before you and I talked. But I want you to explain the difference between the Supreme Court and these inferior court judges, even the definition of that term, inferior court judge, and whether they have a right to be issuing these injunctions. And if not, what we do about it.
Okay, so Liz, great to join you as always. There's obviously a lot to unpack there. Just
Yep,
just for the viewers' edification, there, I don't want the viewers to think that I just randomly from my iPhone texted you 3,000 words. I had written an essay on this and I sent
you
sent you
did.
the link. So I
You
just thought I
did.
would
That's true.
just thought I would clarify that. Okay, so there's a ton to unpack here. Okay, so let's just start with bread and butter basics here. Okay, so Article 3 of the Constitution is the Constitution that establishes the judicial branch. We know from Alexander Hamilton writing in Federalist Number 78 that it was and continues to be the least dangerous of the branches because, in the words of Hamilton, it has neither force nor will, but merely judgment, and depends upon the efficacy of the executive branch, even for the enforcement of its own judgments, which quite literally means that they do not have the ability to actually self-execute their orders. Frankly, even the U.S. Marshals, which are the closest thing that the federal judiciary has to officers of the law to enforce their orders, U.S. Marshals, as you probably know, Liz, they're not actually part of Article 3. They don't work for the U.S. courts. They work for the Department of Justice. So even the U.S. Marshals are actually cabined under Article 2, not Article 3. So the first section of Article 3 of the Constitution is what establishes the federal judiciary. And we know that the judicial power of the United States, in contrast to the legislative power in Article 1 and the executive power of Article 2, the judicial power, according to the words of the Constitution, shall be vested in one Supreme Court and however many inferior courts as Congress may from time to time establish. That's close to
Mm,
verbatim, if not actually verbatim there. So the first thing that I think is worth observing is that all that is actually required is one Supreme Court. Literally every other court across the country, including the U.S. Court of Appeals for the Fifth Circuit, which I clerked on actually 7 years ago. I love the Fifth Circuit. That's the federal appeals court in Texas, Louisiana, Mississippi. It's a conservative leaning court. But all of these lower federal courts, whether they district courts, appellate courts, the Court of Federal Claims, and so forth, they solely exist at Congress's discretion, going all the way back to the Judiciary Act of 1789, passed during the first Congress, one of the first statutes that Congress ever passed, started to establish these lower courts. So, for instance, I saw Sean Davis, co-founder of the Federalist, who put a post on X. It still feels a little weird not calling it a tweet, by the way, but a post on X talking about how the ultimate check that Congress has on the judiciary is just to abolish federal courts there. And is that going to happen anytime soon? No. Could Congress do it? You betcha. Congress has that plenary authority if they want to start really getting their hands dirty there. But that is just kind of a basic point there. And that is very much, that observation is in line with the Hamiltonian notion that the judiciary is the least dangerous of the branches. So the essay that I texted you, Liz, and this kind of gets to the question of so-called nationwide injunctions, the real crux of the dilemma that we face here. And by the way, I think if anything, you're being a little too nice. I think judicial activists is if anything, too charitable here. I like to refer to it as a judicial insurrection, frankly, because the left has kind of normalized the use of the term insurrection. We might as well just take them where their mouths are and kind of then just sling it back in their direction. So I think the relevant question is, does the judicial power of which Article 3 speak possibly encompass the notion of a so-called nationwide injunction? And I guess I'll walk us through the answer here. So going all the way back again to the earliest days of the Republic, many Americans thought time and time again that all three branches of the federal government have the ability to interpret the Constitution as it pertains to their own legitimate spheres of authority. So, for instance, in 1804, Thomas Jefferson wrote a letter to Abigail Adams, the wife of John Adams. By the way, Jefferson and Adams actually hated each other. So, this was actually something of a cross partisan letter writing, you might say here. This was not a partisan issue even at that time there. Jefferson famously said, and I'm paraphrasing here, that to give to the judiciary the ability to decide what is the law, not merely as it pertains to a case properly before, but as to the entirety of the federal government, the law of the land, so to speak there, he said that this would make them a despotic branch. Andrew Jackson, similarly in 1832, after the ruling in Worcester versus Georgia, that was an Indian removal case there. So the common line is that people think that Andrew Jackson said, John Marshall has made his decision, now let him enforce it. His actual quote was a slight twist on that. He said, paraphrasing, the Supreme Court has made its decision and they have found that it has fallen on stillborn ears. But he's basically saying the same thing there. And really, no one understood this quite like Abraham Lincoln, whose birthday I'm born on, my single favorite figure in all of American history. So after the abominable Dred Scott case of 1857, that was the case that infamously said Black people are not citizens, they can never be citizens. It was a moral abomination, it was also a legal abomination. Interesting note that you will appreciate, Liz. The Dred Scott case of 1857 was also the first time that the United States Supreme Court ever fabricated out of whole cloth the oxymoronic faux constitutional law doctrine of so-called substantive due process, which I
Mm.
think people will recognize was also the legal reasoning in Roe versus Wade. Funny how that works. But anyway, going back to 1857, Lincoln the next year in the Lincoln Douglas debates, so those famous Senate debates up and down the prairie state, the state of Illinois, Lincoln said time and time again that he would respect the judgment in the Dred Scott case as it pertains to Mr. Scott, to the actual slave who was at issue there, but he would not extend it a millimeter further. And he carried out that sentiment in his first inaugural address, where he spoke in many, many words about how the candid citizen must confess that if you are to give to the judiciary the ability to decide what is the law for not just for themselves, but for everyone, for the executive branch, for the Congress, and on there, then it similarly would also risk a judicial despotism. And in the words of Lincoln, the people will have ceased to be their own rulers. It wasn't until a somewhat obscure case called Cooper versus Aaron in 1958, almost a century after Lincoln's first inaugural address, that was the first time the Supreme Court ever said that because we are final and binding, we are the law of the land for everyone. So this is the modern myth of judicial supremacy. Because I know you love it when I nerd out, this is actually my first law review article. I actually wrote on this when I was a final law school student. I published it in the University of St. Thomas Law Journal in 2020. It was specifically in the context of the same-sex marriage fight, but I basically wrote a scholarly cri de coeur, you might say, against the fallacy of judicial supremacy. Judicial supremacy is exactly what we are seeing right now. This idea that the judges have the power under the judicial power to issue a so-called nationwide injunction. They do not have such power. In fact, as Sam Bray, the Notre Dame law professor, exhibited in a 2017 Harvard Law Review article, a very compelling law review article, the entire idea of a so-called nationwide injunction did not arise until the late 1960s, early 1970s, the Nixon-Johnson period there. And frankly, it really didn't burst out into the open until the first Trump presidency. Funny how that works. By the time that Donald Trump was done as president the first time, he had 64 so-called nationwide injunctions that were issued against him. By the way, that was more than the first 44 presidents combined. So we've seen this before. The judicial resistance has tried this before. Clarence Thomas, in a concurring opinion in the 2018 case, Trump versus Hawaii, that was his most direct call for the United States Supreme Court to once and for all rule that these so-called nationwide injunctions are illegitimate. Here we are 7 years later. SCOTUS tragically has not ruled on that issue. But Liz, I do think that day is coming sooner rather than later, God willing.
So in the YouTube live chat, Alan says this is actual teaching of school here, no joke. And I think that's exactly right. That's why we have Josh on the show, because he tells us what we need to know. So let me summarize what you said to make sure that I understand it and everyone else understands it. To summarize what you said, no, the inferior court judges, which are lower federal court, whether it's appeals courts, which are allowed to be established by Congress, but not mandated to be established like the Supreme Court is under Article 3. They do not have the authority to issue nationwide injunctions, basically because they were created by Congress to help the Supreme Court, to make sure that the Supreme Court's caseload isn't as heavy, and that the Supreme Court has the authority to possibly issue an injunction because they're allowed to and you can tell me if this is judicially imprecise language here, but they're allowed to issue rulings that are precedent setting, meaning that ruling can apply to similar cases, but lower level courts are only supposed to apply to the actual individual plaintiffs at hand. Not It's not supposed to set a precedent. Is that an accurate summary?
So I would actually probably go even further, actually. I think that the United States Supreme Court itself does not have the ability to actually bind the executive branch or the Congress beyond the actual parties to a lawsuit. So in my opinion, the judicial power of which Article 3 speaks is the power to apply the law and render a judgment as it pertains to the actual people before you, to the litigants. You're basically deciding a case. You're literally deciding a controversy, a case or controversy in the nomenclature of Article 3 there. But I take the Lincoln approach, which is that anything beyond that, extending it a millimeter beyond that there, it depends upon the persuasive authority of the actual judicial ruling there. I mean, there's a reason, Liz, that these things are called opinions, because it's ultimately an opinion there. And as we know from Hamilton and Federal 78, they can't even enforce it there. So in order to enforce it, they have to be persuasive, they have to be compelling there. So no, there's no such thing as a so-called nationwide injunction, and the Supreme Court really desperately has to weigh in here sooner rather than later. But yes, to your point, it is doubly insane for the lower courts to do this there. I think it's crazy, frankly, for the United States Supreme Court to purport to be the final exclusive and sole interpreter of the Constitution. That is the analytical error that the court made in Cooper versus Aaron, establishing modern judicial supremacy in 1958 there. So just to give an example of that, before the Dobbs case, thank God, overturned Roe versus Wade, I actually said for years that the coordinate branches, so Donald Trump when he was president, should actually just not follow Roe versus Wade because, in my opinion, it only bound Roe and Wade in that particular case. There, it was only persuasive authority, aka not persuasive at all, beyond those particular litigants in the suit there. So I would actually take it even further. But for present purposes, these lower courts, who again exist solely at the discretion of the Congress, there, this random judge in Hawaii or Maine or Seattle or South Florida, where I live, there, the notion that you have the ability to bring the entirety of Article 2 of the federal government to a halt is bat crap insane. Lincoln is rolling in his grave at the thought of this. Thomas Jefferson, so many of the greatest Americans never in a million years would have contemplated this. And in many ways, Donald Trump is I think, trying to make what we constitutional law nerds would refer to as departmentalism, namely the idea that all the departments of the government can interpret the Constitution for themselves. I think Trump's trying to make departmentalism great again, and I salute him for it.
Okay, so when you say that you maybe expect or it's beyond time for the Supreme Court to weigh in on this, what do you mean? Like, would they instruct the lower court? Would they have to rule on a case? Like, explain to me what you mean by that.
So they have a lot to rule on. I think is the short answer here. I mean, including on actual underlying substantive constitutional questions such as the birthright citizenship question there. So there's a lot that they're going to have to rule on here sooner rather than later. But I think that immunitizing, so to speak, the nationwide injunction ruling is probably the number one most pressing priority here, because without a definitive ruling that ends this entire charade, this judicial insurrection there, the executive branch is effectively brought to a halt. And the way that works is that the DOJ has to tee it up. So the Solicitor General of the United States, the acting Solicitor General, because John Sauer, I do not believe has been confirmed yet as the actual Solicitor General. So the acting Solicitor General and the acting Office of Legal Counsel, all the various lawyers there in the DOJ bureaucracy who work on filing cert petitions, which is kind of a fancy legal way of saying that's how you get a case before the Supreme Court there. You guys should be appealing one of these so-called nationwide injunctions and trying to directly tee up for review for the Supreme Court. The straight up legal question is a so-called nationwide injunction compatible with Article 3 of the Constitution? Is this encompassed within the so-called judicial power there? Now, it's a so-called rule of four. You need 4 of the 9 justices to actually grant cert in a particular case. That's less than a majority, frankly. And I think they have the votes. I would be shocked, frankly.
Who?
I'd be flabbergasted. Who? I think, well, clearly Thomas Alito and Gorsuch, I think, will be very skeptical of nationwide injunctions there. And from there, you would need one of Roberts, Kavanaugh, or Barrett. I honestly, I think it's a possibility that all 3 of them would want to weigh in there. Really, I mean, what you're dealing with here. John Roberts likes to talk a big game, Liz, about the legitimacy of the court there, or the perceived legitimacy, and he has a rather peculiar way of going about that. I think would be a charitable way of saying it, but surely, at a time like this, where half the country is looking at these far left lower court black robe tyrants trying to put in their chambers in Rhode Island or California, try to bring the entirety of DC to a halt there. That is a major glaring red flag problem for the legitimacy of Hamilton's least dangerous brand. So I think that even Roberts should be sympathetic to it.
So the Trump administration could today, if they wanted to, through the Solicitor General, file an appeal with Supreme Court on one of these nationwide injunctions, and thus encourage, it couldn't force the Supreme Court to rule, but encourage the Supreme Court to rule on this and actually address the nationwide injunctions. In the meantime, if it is so obvious, which I think it is pretty obvious, it's a little nerdy, but if you look at everything that you laid out, the constitutional role of the judiciary, what the judiciary is doing, and the judiciary is kind of like an all-encompassing term, right? The Supreme Court, it's different than these lower courts. Do we have, or does the Trump administration have an obligation to follow these nationwide injunctions while they are pursuing legal recourse, or because they are so blatantly unconstitutional, should they just ignore them and proceed?
In my opinion, the administration only has a legal obligation to follow a judgment as it pertains to the named parties to a particular lawsuit. But you don't have to actually extend it a millimeter further. So, I mean, just to give one example of that, okay? So birthright citizenship, let's take that because
Yeah.
that's a very high profile piece of litigation. By the way, Trump's totally right on the 14th Amendment actual argument. I wrote a column on this a few weeks ago. I've been arguing this since I was a first year law student. So he's totally right on the actual substantive constitutional question over the 14th Amendment. Nonetheless, you've had at least three judges thus far who have ruled, and they've put on various types of temporary restraining orders or injunctions trying to sweep the nation there, that he actually can't do this. Okay, well, who's actually going to sue then in that case in Seattle, Washington? I mean, who is the underlying plaintiff there? I mean, is it someone who was born to illegal alien children? Let's just make up a country here. Let's say that person was from Honduras. Okay, so then that judge's ruling actually binds that particular Honduran national, and he actually has citizenship for now under that judge's ruling there. But the notion that this ruling in Seattle, Washington about a Honduran national can possibly bind people who are born here illegally in my state of Florida or in Ohio or Massachusetts or whatever from all over the world, it's crazy. You actually do not have to respect that judgment, and you actually do not have to issue a passport or a social security number or anything like that. That would be my understanding as to the extent to which the Trump administration is bound.
Okay, so is that what the nitty-gritty of those rulings? Because I think you're right. It's 3 or 4 judges now who've ruled against Trump's executive order on birthright citizenship. Were they all cases where there was an individual plaintiff, like a child who was born here in the United States and presumed to be a citizen, but the parents were illegal aliens, and Trump saying, "Actually, that doesn't make you have the presumption of citizenship." Was it an individual case that was ruled on? It wasn't just a, "Hey, we don't think that this executive order is legal"?
So I would have to go back and look, but again, in my opinion here, the latter thing you're saying, this entire idea, and lawyers call these facial challenges, right? So this is the
Yeah.
idea that you can go in and just facially challenge an executive order or statute because in every instance of its application, it is here, there, and everywhere unconstitutional. That's how you got a lot of these NGOs, liberal
Yeah.
nonprofits, groups like the ACLU that are able to go in and try to facially challenge there. In my opinion, again, because I'm something of a judicial minimalist when it comes to the actual separation of powers, I think the entire notion of a so-called facial challenge is illegitimate. It is erroneous. There should not be such thing as a facial challenge for the very same reasons that I just laid out over the past 20 minutes of our conversation, which is that
Where did that come from? The idea of a facial challenge? Like, when did that come into our politics?
so much of our modern judicial supremacist myth is a post World War II, post 20 second half of the 20th century phenomenon. Now, I'm being a little tongue in cheek here. So after World War II, there was a statute passed called the APA, the Administrative Procedure Act. It was really the bane of my existence back in admin law class, back in law school. It's a terrible statute. And this is really kind of the legal backbone of the modern administrative state, which is of dubious legitimacy in the first place. But under the APA, under the Administrative Procedure Act, there are very limited procedural grounds to try to secure a facial challenge there. I honestly don't remember exactly what those specific types are. So, according to the statute, there are some ways under modern litigation that you are at least statutorily authorized by the Administrative Procedure Act to go and seek a facial challenge and get injunctive relief. But again, this is all unconstitutional in the first place.
Right. And I mean, it's fascinating. Like I said, I this is it. We waited for the resistance. We waited to see if they were going to break windows and torch our buildings and assault cops, throw Molotov cocktails. If it was going to be Black Lives Matter or Antifa, or whether they were going to try to assassinate Trump or lawfare him again, impeach him, or what they were going to do. This is it. In my opinion, this is it. And I don't think that this is isolated to 1 or 2 corrupt judges. We're going to talk here shortly about some of these individual judges, because I want you to weigh in on the conflicts of interest, which again might be a very charitable term for what some of these judges have in their backgrounds. The conflicts of interest that these judges have, and what we should do when a judge, and I'll give you an example. I actually don't want this to be hypothetical. Let me bring this up because this is Judge Matt Bates. He was the judge that said that President Trump cannot or must restore the gender ideology web pages to the websites of our federal government public health agencies. And he has a financial conflict of interest in his background because his wife gets money from, believe it or not, USAID. You just can't make this stuff up, right? Like the tangled web of Washington D.C., this swamp is beyond imagination. So his wife gets U.S. aid money, U.S. aid being the U.S. Agency for International Development. That isn't really that. It's a CIA front. It's used for color revolutions abroad, regime changes, and it's been used against the United or against U.S. citizens. It's used against us. It's the hub of the censorship industrial complex. They basically censor us on social media, saying that we are threats to democracy. Which is also what they said, if there's anything abroad, it's a threat to democracy. Therefore, the US is going to use US aid to try to influence the politics abroad. They've applied that playbook here at home, which is why Elon Musk not only DOGE'd it and exposed the corruption, but why it appears that it's going to be shut down entirely because all of these US aid employees have been, or most of them, I should say, if we're being precise, have been fired. And they found out that they were fired by a post on the USAID website. Judge John Bates, who issued this ruling against Trump, his wife gets US aid money, which, again, to call it a financial conflict of interest might be an understatement. When a judge is in a situation where there's a conflict of interest, what responsibility or obligation, because we do live in a civil society, we want to make sure that we use the proper recourse when something's illegal, we don't want anarchy. What is the proper recourse or reaction or our obligation to follow these rulings when we know that they are corrupt?
Well, first of all, the proper thing for the judge to do is obviously to recuse where there is an actual conflict of interest.
Right.
There's no enforcement mechanism on the recusal decision. It ultimately is up to the discretion of a certain judge. But just to give you one example, Liz, so the amazing judge that I clerked for on the Fifth Circuit 7 years ago, Judge James C. Ho, who I personally hope will be sooner rather than later Justice James C. Ho. I think he'll be an amazing justice there. His wife Allison is an extremely high-profile litigator there. So situations do arise where on the Fifth Circuit, on the court where my former boss sits, that his wife might be an active lawyer on the case, and that is an obvious conflict of interest, and he obviously cannot sit on that there. So decent human beings, people who actually respect the judicial system, people who respect the court system, who respect, frankly, the rule of law itself, are able to arrive at fairly obvious conclusions when it comes to the recusal decision itself there. But on the actual case here, I mean, the judge is purporting to tell the administration what it can and cannot put on its website when it comes to genders or chemical castration mutilations there. I mean, dude, like you literally cannot do that. I mean,
Like he
as
has
we
no authority to do that, correct?
zero. I mean, as we just established over the past half hour of chatting here, the president of the United States is responsible for interpreting ultimately the Constitution, but also statutes, treaties, everything passed pursuant to the Constitution as it pertains to his executive branch. The notion that the president of the United States doesn't have absolute final period, full stop, end of story control when it comes to such a basic prosaic question as how many genders the federal government recognizes for purposes of DHS and state and all the various parts of Article 2. Insane.
It's
Absolutely
so
insane there.
insane.
It's nuts,
It's I mean,
Liz.
it's so insane. So then we have a Rhode Island judge by the name of John McConnell. I assume no relation to Mitch McConnell, although that would be kind of funny to be honest. He's but none that I know of, just to be clear. He's the one who issued the injunction halting Trump's executive order that would stop spending. Right, he halted Trump's spending freeze. Well, it turns out, and this was reported by America First Legal, that Judge McConnell appears to currently serve on the board of directors for an NGO, that's a non-governmental organization. Although, as we have learned, thanks to Elon Musk's doging of the federal government, especially USAID, these non-governmental organizations are usually funded by the government. So they're essentially an arm of the government if they get all their money from the government. Judge McConnell currently serves on the board of an NGO called Crossroads Rhode Island. This NGO received $118 million. $118 million in government funding since 2009. So this guy serves as a board member for an organization that needs the money that Trump cut, and he restored it with a judicial fiat. Again, I hate to I don't want to sound like an anarchist. I want to respect our systems. I want to respect the judiciary. But when you get rulings like this, how can you do anything other than say just ignore it and go about your business? It's ridiculous.
Well, I also saw a clip that Natalie Winters of War Room pulled from Judge McConnell. I think I saw that from Natalie last week, and this clip is from 2021, so it's maybe less than a year at the most after the death of St. George Floyd, our martyr, and the whole Great Awakening and all that there. And this clip is of Judge McConnell there in judicial chambers, doing some sort of Zoom or conference call, whatever, talking about how, oh, he's a privileged white man. But when it comes to applying the rule of law to blacks, Hispanics, to LGBT, whatever, you have to meet them where the law is. And it's like, dude, whatever happened to equality under law? I mean, last I checked, equality under law or equal justice under law was actually still there outside the United States Supreme Court. Last I checked, equality under law was in the Declaration of Independence. It was in the 14th Amendment. It's in the Civil Rights Act of 1964. Frankly, it's right there in Genesis 1:27. To me, that's really kind of where the entire idea of human equality starts there. I argue in my
Yes.
forthcoming book, by the way, that notion of genuine human equality is the entire foundation of the Western order in general there. So these people are just being willfully disingenuous. They're being willfully blind to what
Yeah.
is clearly right before them there. By the way, in this particular case, this is actually probably my favorite one. This judge here is threatening the Trump administration, DOGE, and so forth with criminal contempt. Unless they submit their funding decisions through his puny little desk in Rhode Island there. And I kind of look at that and I say, okay, I mean, like, let's play this out. Okay, so you want to threaten criminal contempt. Tell me how that's going to work. So, first of all, again, the one who would actually enforce the contempt order is the U.S. Marshals, who last I checked served under Pam Bondi. She could very easily just say, no, don't do that. But let's game it out even further there. Let's say that Pam Bondi says, okay, for respect for the coordinated branch there, which they don't really deserve in this case, but let's just, for respect there, go ahead and enforce that criminal contempt order. Go ahead and serve Elon Musk with contempt. Well, what can Donald Trump do, Liz? Donald Trump can just pardon Elon Musk. I mean, last I checked, Joe Biden was teaching us a civics lesson in the extent to which one can use or abuse the pardon power there. So, I mean, he did that on the way out the door. What's good for the goose is certainly good for the gander. This would be far more legitimate than my God, than what he did with those preemptive pardons for Fauci and the Biden crime family, whatnot there. So, ultimately, again, I come back to the Hamiltonian notion in Federalist 78 that it is the least dangerous branch because they really just are ultimately impotent.
Yeah, I mean, I see rulings like that from a judge that corrupted, and my reaction is just be gone, nuisance, be gone, nuisance. Like we are not going to give you the time of day. This is actually one of the areas where conservatives, I think, have matured a lot in the last 8 years since we've just seen the depths of the evil within the resistance to Trump. And we've said, wait a second, we are not going to be naive anymore. We're not going to be almost dumb in our kindness to others anymore. We want everyone to be prosperous. We want everyone to cooperate. And in the past, we've fallen for this false notion of compromise and giving people the benefit of the doubt, and we've been taken advantage of. And so I feel like there's this new savage based energy that conservatives have brought to the table, especially in this Trump administration, where we're like, wait a second. We are not playing games here. This is a test. They are seeing how far they can push us. They are testing us to see, are you ignorant enough of the Constitution? Are you ignorant enough of the law? Are you willing to let extreme conflicts of interest and just utter disregard for the rule of law in our nation? Are you willing to let that go? Can we push you this far? Because we'll push you a little bit further, because they don't think that we're going to draw a line in the sand and say, no, stop, do not comply. We're not going to let them rule us by judicial fiat. And I think this is one of those moments. This is going to be a test for the entire Trump administration and all of MAGA as well, to see, is this resistance going to be successful, or are we going to stop it right now? I want to talk to you about DOGE, the legality of DOGE, and why we can actually thank Barack Obama for why DOGE is legally airtight. But first, I want to talk to you about American Heart for Gold, because in all the time that you and I have been alive, the US dollar has always been the primary currency. And it's been good to be able to count on that. But what if we aren't able to count on that as much as we previously thought? The US dollar, we know, thanks to Biden, is facing unprecedented inflation. Politics around the world is getting increasingly unstable, even here domestically. I mean, what's the theme of this episode? That there's this resistance that wants to commit a judicial insurrection against the Trump administration, against you and me. It's scary. And then, of course, you have these globalists who are looking to take control over all of our money with the introduction of a digital dollar. Let me tell you, it has never been more important than to take control over your wealth so that you cannot be controlled. Don't let your life savings become a casualty of failing banks or currency wars. Now is the time to call the only precious metal dealer I trust, American Heart for Gold. They'll show you how to protect your savings and retirement accounts by diversifying your wealth portfolio with physical gold and silver. My husband and I just did this. Part of our wealth portfolio is now in physical gold and silver, precious metals such as that. American Heart for Gold is a wonderful company. They stand with us here on the Liz Wheeler Show. They're proud to be partners in this endeavor. They're proud to be partners with a show that's committed to bringing you the truth. Tell them that I sent you, and they'll give you up to $15,000 of free silver on your first order. Call them now. Click the link in the description of this episode or call 866 996 5172. That's 866 996 5172 or text Liz to 998899. Again, the phone number is 866 996 5172 or text Liz to 998899. Okay, let's talk about DOGE for a second. There is, of course, I guess, the underlying question of all of this too, besides the role of these judges and these nationwide injunctions and what the Supreme Court should do with inferior court judges that are overstepping their boundaries. Is DOGE actually a legal entity? Because it wasn't established by Congress; it was established by executive order. Is Elon Musk, does Trump have the authority to give Elon Musk access to all of this information and then act on this make these spending cuts accordingly? There is a lawyer by the name of Tom Renz from the state of Ohio who read the executive order that that President Trump issued about DOGE, and he says not only is DOGE legal, it's actually legal thanks to something that Barack Obama did. So I want to read you just a little bit of what Tom Renz said. He said Barack Obama created United States Digital Services, USDS, in 2014. It was meant as a bureaucratic patch job to fix the Obamacare website meltdown. You guys remember that, right? Fast forward to 2025, Trump rebrands it DOGE, United States DOGE Service. Keeps the acronym, keeps the funding, but gives it a whole new mission: find the receipts. Legally untouchable, Tom Renz writes, because it was already fully funded and operational. Trump invokes 5 USC 3161, which allows him to create temporary hiring authorities. DOGE teams get embedded inside every single federal agency. Each team consists of a lawyer, HR rep, a Zoomer nerd, and an investigator. They report to DOGE, not the agency they're embedded in. But wait, there's more. Trump invokes 44 USC Chapter 35, which governs federal IT and cybersecurity oversight. Since USDS was originally an IT oversight body for the Obamacare website, DOGE now has full access to all federal data systems. All of them. Okay. This is, first of all, it's just funny, right? It's extremely funny that this was an invention of Obama. But give me your analysis, Josh. Is this correct?
So full disclosure, I have not heard that actually. But if it's correct, then it's correct. I mean, that's totally genius, actually. If that's mechanically what Trump did, I agree with the invocation of the statute that he invoked 5 USC. I forgot the exact number, but that legally makes sense to me there. So that's totally genius there. I guess, look, the only other point that I would make there, I mean, the name Doge, I mean, I think people are thinking like, oh, is this like a new Foggy Bottoms? Is a new State Department? Is a new Pentagon there? And no, like it is not a creature of Congress insofar as it is not formally vested with all of the appurtenances and all the formalities that acclimates to the Department of Justice or Treasury, anything like that there. I think the best way to think of Doge, because they're physically housed inside the Eisenhower Executive Office building, which is basically right next to the White House there. That's where the Domestic Policy Council sits there. They're functionally similar to folks like the Domestic Policy Council, like the White House Counsel's Office, some of the most senior officials within the executive branch who have a lot of authority, whether directly from the president or just on a purely advisory basis there. I mean, that ultimately really is what DOGE is, Liz, right? I mean, DOGE
Yeah.
is not they're not necessarily the ones who are going in there and literally saying, you know, you have until 5 p.m. today to clear out there. Ultimately, these decisions get made by the president of the United States because he is the one who has the executive power there. But they have all the ability in the world to advise the president, and the president has all the ability in the world to choose who he wants to advise him there. And yes, as a legal matter, if what this lawyer in Ohio says is correct, which again I plead ignorance on, I just haven't heard that, but it sounds totally genius. If that is correct there, then I do think that DOGE is on even firmer grounding than it has to be there. Various other parts of the Eisenhower Executive Office building, things like the Domestic Policy Council, were actually codified by statute. They're not all creatures of the executive's kind of pen and a phone, so to speak there. So if DOGE has a legitimate statutory basis and not just an executive order, then that definitely does, I think, further legitimize it.
Because there's basically two questions, or two ways, I should say. It's not really questions. It's two ways that the left is trying to attack DOGE. They're trying to say that Elon Musk and DOGE don't have the authority to have access to all of this information, and then they're trying to attack President Trump's authority to slash discretionary funding. And we can talk about the discretionary funding aspect, but I would like you to weigh in on who's behind these judges, who's behind this influx of nationwide injunctions. And that's, of course, the lawyers Mark Elias, who those watching the show are going to be very familiar with the name Mark Elias because we talked about him at length in 2020. He was behind a lot of the lawsuits that changed the rules of the elections in the name of COVID, universal mail in ballots and unmanned drop boxes and the degradation of signature verification, all that kind of stuff, accepting absentee ballots after election day. Mark Elias was the architect, if you will, of that strategy to decrease our election integrity. Norm Eisen is a name that some people have been familiar with for a long time. I can see some people talking about him in the live chat here. So we have a lot of very involved citizens who are part of the Liz Wheeler show. But there was an organization that was started, a group that was started in December of 2024, and I think it's really incumbent on us if we want to fight back, we want to prevent this type of lawfare strategy from being effective. We need to understand what Mark Elias and Norm Eisen has been doing. So on December 19th, to be specific, of 2024, Mark Elias launches a group called Civil Service Strong. Now, civil service is, of course, the name that's given to most of the 2 million federal employees, those who aren't at the top of the agencies, the political appointees. The rest of them are called civil service employees. Mark Elias launches this group called Civil Service Strong, and it's essentially a coalition, if you will, of a lot of groups that represent the 2 million federal government employees. I don't really like to call them civil servants. I'm sure some of them are good people, but most of them are swamp creatures. And this group was formed to go after Trump during his second term. They were formed to bring lawsuits against Trump that would lead to these nationwide injunctions. This is the purpose of this group. And almost every single lawsuit, Josh, that has been filed against the Trump administration thus far that's led to these nationwide injunctions has come from this group. This group is their strategy is interesting because it's not just Mark Elias, it's not just Norm Eisen saying, hey, we oppose this, we want to file a lawsuit. It incorporates Democratic attorneys general. So attorneys general of blue states that have an unlimited war chest of taxpayer dollars to bring these lawsuits against the Trump administration. And not only is it important for us to recognize that this is not, a one-off lawsuit, so this is a coordinated effort by Mark Elias and by Norm Eisen, but I would love to hear your take on Democrat attorneys general who bring these lawsuits at the behest of Mark Elias, who have this taxpayer funding behind them. They're not like some nonprofit that's like, oh, do we have the money to bring this lawsuit? No, they have taxpayer money. They can do what they want. What is your take on this? How does the right combat this?
So let me first say that there's actually nothing inherently illegitimate, right, about a public solicitor general or attorney general's office working with outside groups. I say that because we on the right do it as well. So, for instance, Stephen Miller founded America First Legal after
Yeah.
the 2020 election. America First Legal, fabulous organization there. I love the work those guys are doing. They also have worked with many red state attorneys general offices, including Ken Paxton in Texas and so forth there. So, I mean, to an extent, this is allowed. I mean, lawyers can go in together to litigate cases there. I think the problem is the method that they are doing it here, which is they are kind of running in like a bull in a china shop. And I don't know exactly where they're getting all this money. You're right that Mark Elias started talking about it in December. I think back a little bit. It was around the time that my daughter was born, so I was a little tuned out of the news, to be honest with you. But I do remember seeing a headline about how Mark Elias was starting this thing. Mark Elias is a name that goes back a very long time. I mean, people who are familiar with left-wing litigation circles will be familiar with Mark Elias, along with people like David Boyce. These are some of the left-wing Democrat litigators that have been just prolific household names within that niche sphere for 25, 30 years. So he presumably has absolutely prolific donors. I mean, I don't know exactly who they are there. I'm sure they're getting money from folks like George Soros, like Open Society, like the Tides Foundation, many of the same people that have been involved not merely in the 2020 election, but in trying to advance left wing causes all around the world. They pumped all sorts of money into NGOs in Ukraine. They've been trying to foment color revolutions, as you said earlier in the show, all throughout the world in many ways there. I would imagine there is a lot of overlap, frankly, when it comes to the donor pool for these particular causes there. So I'm not surprised that Mark Elias is behind effectively all of these lawsuits. I'll be honest with you, I had not actually realized that he was almost singularly behind it there. I'll take your word for it. But, look, they have a lot of other activist litigation outfits too. I mean, I mentioned the ACLU earlier in the show. They have a lot of people who are willing to get their hands dirty and go into court there. We on the right typically lack that infrastructure, with the exception of groups like America First Legal. But up until Stephen
Mhm.
Miller founded America First Legal, we were severely lacking. Yeah, there are some specifically kind of property rights centric libertarian litigation outfits, groups like Institute for Justice, Pacific Legal, but they really are kind of just they pale in comparison, frankly, to the left wing public interest litigation infrastructure that the left has there. We're only just now playing catch up on the right. I hope that we get there sooner rather than later, though.
Yeah, it like I said, this it last week it just hit me. It just all of a sudden everything became crystal clear. I was like, listen, I didn't know if they were going to commit political violence. That's what I was afraid of. I was afraid they were after the election, they were still going to try to throw Trump in jail. And because
Yeah.
they wanted political violence, they wanted some crazy Trump supporter who was righteously indignant and outraged about the injustice of trying to put a sitting president in jail for something he didn't do. They wanted that act of violence so that they could then brand all of us as the terrorists, which they have already verbally branded us as simply for being Trump supporters, and thus, usher us into essentially a civil war where they could tyrannize us and violate our rights. I was worried, frankly, that that was going to happen. I thought that there was a very realistic chance that that would happen. I think the reason that it didn't happen is because Kamala Harris drained the DNC war chest. Kamala Harris, all of those Black Lives Matter riots, the Antifa autonomous zones were funded. They were not organic movements. They were not grassroots movements. They were not individuals. They were funded by these radical left wing the donor class, and
Yeah.
Kamala Harris drained all their money during the election. So I think one of the reasons the political violence didn't happen in the immediate aftermath or even after the inauguration was because they have to regroup. But that, like I said, that doesn't mean that they weren't going to do anything. It doesn't mean that they were going to sit quietly while essentially their infrastructure, their deep state embedded in the swamp, was eliminated by Elon Musk at the behest of Donald Trump. They weren't going to sit still. And it became crystal clear to me that this is what they were going to do. This is it. This is the resistance. We have to understand it. We have to break it down. We have to follow the money. We have to make sure that we have an airtight defense, that we have a strategy to implement, that we can articulate it, and that we don't fall for it for a second, that we don't say, oh, well, a judge says we want to respect the judicial authority. No, 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 no. Do not let them push you, because if they push you an inch, they will push you a mile. We actually have so much more to reveal about these judges and Norm Eisen and Mark Elias, but we have, Josh, run out of time for today because you have given us such a thorough education on, I should say, I feel confident now dismissing these nationwide injunctions after your legal education. So, for everybody watching, we'll be back tomorrow with more. We have a lot still to say about this topic because it is the most important thing that is happening right now. So make sure you subscribe, youtube.com/Liz Wheeler. Go to x.com/Liz_Wheeler on Apple, on Spotify. Hit subscribe over there. And we will return tomorrow for a continuation of this episode. Josh, thank you for being with us today.
Always great to join you, my friend.
All right, guys, I'm Liz Wheeler. This is The Liz Wheeler Show.